Hello, good morning, good afternoon, or perhaps it's evening. My name is Herricia Willis. I'm an attorney at law practicing in Grenada for the past 6 years. As a slight background, I'm also an attorney at law in Jamaica and admitted as a solicitor of the Supreme Court of England and Wales in 2000. Well, I'm here today to inform you of wonderful news. I intend to advise and promote law in Grenada because Grenada matters.
Good evening, Herricia. How are you?
Good evening, Ingram. I'm fine, thank you. And you?
Fantastic. I'm good. I'm looking forward to learning more about probate and learning more about more legal terms and more legal understanding.
Thank you. I'm here to help.
Okay.
After our restful week, last week in Grenada was Independence.
And how was that for you?
Very restful. We are all under lockdown, as you know.
You were under lockdown as well?
Well, we still in the evenings, but not like the UK. Ours is from 10 till 4 a.m. in the morning is curfew.
Okay. And how's that affecting the Grenadians?
Well, they're just thanking that we have no to none COVID here.
I also understand that the vaccines are on their way, or they're already on the island.
It's already on the island, and I believe, I've not seen it, but I think it's on the news. Our Prime Minister has taken his shot.
Okay. So it looks like, as we said, it's on its way. The vaccination, I think we spoke about it last year. The vaccination is coming to Grenada. I think people probably took us as seriously as now's the case of vaccination. And
that is correct. It's here.
Well, it's here.
We'll see now.
Okay. So this evening, our topic will be the validity of a will.
Yes, it's still under probate, but this is to do with the will, how and why a will becomes valid.
Okay. So first question is, for those people, make it very basic. What is a will?
Well, a will is the testator. A testator is the person writing the will. It's his wishes on his death, what he would like to do with his assets after death.
Okay. So then, what would make a will valid?
Well, the majority of jurisdictions have their own Wills Act. Grenada has its own Wills Act. So when an individual is writing their will, it must comply with the rules for making a will under that act. So that when the person makes the will and after their death, their will has legal force. Of course, as long as it is followed.
Okay.
There's some requirements for making your will for it to be valid. There's several, but three very important requirements. The first one is the will must be in writing. We now have computer. Before it was typewriters, or it could actually be in your own manuscript words, but it must be in writing. Secondly, it must be signed and dated by the person making the will. And finally, and most important, the individual's signature must be witnessed by at least 2 witnesses.
Okay, who could these 2 witnesses be?
It could be a family member. It could be a stranger. It could be a neighbor. As long as the individual is not a beneficiary under the will, they can actually witness the will, because basically they cannot inherit or benefit from the will if they are a witness.
Okay, so they have to be independent of the beneficiaries. In that case, you're saying
You cannot benefit from the will if you're going to witness
yes.
the individual is making the will. You cannot benefit from it.
Okay.
That's the golden rule, basically.
Okay, so on a will, there are certain, for example, there's a thing called an executor on a will.
That is correct. Executor is the person you select to carry out your wishes.
Okay.
The definition is a legal representative named in a will to handle an estate when somebody dies. Well, depending on the size and the complexity of the estate, and of course the deceased person's financial affairs, the person acting as an executor, their task can be difficult and time-consuming. Okay. This is because the executor has the authority from the probate court to manage the affairs of the estate.
Okay. So what are the rules for making an effective will?
Well, the rules, let me summarize it as this. Bullet points, 2, 4, about 5, I can say.
Okay.
First one, of course, you must know your assets. What are your assets? Your assets are your money, your possession, and the property you own, real or personal. Of course, real estate, you know, that's property, house, so forth. Second one, you must understand the effects of your will. I mean, you must understand what will happen when you die and the consequences of including and excluding certain individuals. So, secondly, that's understanding the effects. The third one, you've got to approve of the contents of your will. You must make your will of your own free will. Excuse the pun. And fourthly, knowing that you are signing your will and that signature that you put on your will have legal consequences. And of course, finally, you must follow the correct procedure for signing your will and having your signature witnessed. Because if you recall, I say you need at least 2 witnesses, and the witness must witness you signing your will. So, for all what I've said, when you're making your will, you must understand what you're writing about. That means you must have sufficient mental capacity at the time that you sign the will. That is to be able to comply with all the rules under the Wills Act.
You mentioned something about being influenced into, it's a lot of pressure, especially with an elderly person, when they, life, people think, well, you're getting on a bit, you need to do a will, and then they may feel pressured to put certain things in the will.
You'd be surprised, this happens quite a lot of times.
Mhm.
It's duress. That can happen. And we'll go on to that when we're talking about the consequences, the legal consequences.
Okay, cool. So you talked about a witness earlier on, a witness. Let's go back to who can witness a will.
Well, a will can be witnessed and signed by anyone over the age of 18. Yes?
Okay.
As we said, a neighbor, a friend, or a colleague. But you can't benefit. Any person who cannot benefit, we've said that already.
Cool.
Okay?
Okay.
So the only rules are that they cannot be a beneficiary of your will, married to a beneficiary, or the person is blind. Because if they're blind, they can't witness you. It happens, Ingram.
So Stevie Wonder could do my will then.
Definitely not.
Or Ray Charles. No?
No. Well, Ray Charles is dead, so he definitely cannot be.
Okay, moving on. The next one.
Okay. Right, the law in England and Wales. That's quite important because in the Commonwealth, the law in England and Wales are sometimes relevant.
Right.
But this is also relevant, what I'm going to say, about a medical practitioner witnessing a will. In England and Wales, it's recommended that anyone who's elderly or seriously ill should ask a medical practitioner. This rule also applies in the Caribbean, be it Grenada, Jamaica, St. Lucia. It is recommended if an individual is elderly or seriously ill, they should ask a medical practitioner. So this is particularly important if you are mentally ill or you have terminal illness, because you need to be able to demonstrate that you have testamentary capacity. That's the word when writing a will. So if you feel like this might apply to you, because there's a reason why you're listening to this video, you should ask your GP or a specialist to witness your will. I did say earlier that it is much suitable and favored if there are two individuals who witness the will. If you have a medical practitioner, you still should have the two.
So, is there any reason why a will or can a will be challenged? That's the question I should ask you.
Of course, a will can be challenged and held to be invalid. There are a number of reasons why this could happen. The will has not been properly signed or witnessed, because remember, that's the three conditions, that's one of them, or two of them. This could be because the solicitor, attorney, or even the will writer who's helped prepare the will failed to give proper instructions as to how the will should be signed and witnessed. Because it's for those individuals to tell the testator, that's the person who's making the will, the proper instructions on what to do. The will can also be challenged to be invalid if it is made without professional help. It might just be the fault of the person making the will. So it's not just for professionals to adhere to the proper signed or witnessed criteria. Will be challenged another time. At the time the person who made their will, they could have been ill or injured and they did not have the necessary mental capacity. Remember, I mentioned that. This might be because the person is suffering from a head injury or they've been ill, such as dementia or, let's see, Alzheimer's.
Mm-hmm.
in these circumstances, medical evidence of what they could understand at the time is crucial. And another important, and it's happened quite a few times, if the will is not the last will,
Okay.
the will that's been brought up and it's found later date that there's another will,
That's not the last
that
one, is
is
it?
the right. So the most recent one is lost or destroyed. The will should be reconstructed.
Okay. Okay.
There's
So.
another one, very important.
Mhm.
If the will was part of a fraud.
Go ahead then.
See, that's important, yes? Because this could happen when the person making the will was misled into leaving someone out of the will, or where somebody has unduly influenced a person to make the will in their favor, or even to leave them a large gift to them without the person dying ever knowing, if you understand my take on that. Ingram? I think I may have lost Ingram. As I've lost Ingram, maybe I should continue talking on. We might as well go on and talk about the consequences of declaring a will invalid. In these cases where a will is declared invalid, it can have serious legal consequences as it cannot be followed. It means that either the person's previous will that was valid when it was made will apply, even if that previous will was made a long, long time ago. Or when there was no previous will, then the law will follow the rules that apply when somebody dies without a will. I spoke of this before in testimony.
Okay. Slightly. We just want off camera for a moment, but I'm back. My apologies.
Yes, I spoke about the consequences of declaring a will invalid.
Okay.
I
Excellent.
mentioned just two instances.
Right. Is there any more instances?
Not that I can think of off the top of my head.
Okay.
We spoke about undue influences, didn't we?
Yes. Yes. Well, you were talking about it beforehand. Yes.
That's right.
Correct.
So basically, if anyone is concerned about the validity of a will, they should seek legal advice on the particular details of their circumstances, because everyone's circumstances is different. This could be to defend the will where you benefit from it being held to be valid.
So what about a situation where you feel that in the will you should be getting more money than the other person, for example, because this must be family squabbles. Money is normally the root of most of these inheritance things. I should be getting more money because I'm the first son. I should be getting money because I'm the first daughter. Why are you getting all the money? Why is the money gone to the dog? That sort of thing. Because people give money to the dog in the house and the dog.
Or instead of their children, if they know the children are squabbling over their assets, individuals have left all their finances to the dog's home or so forth.
Yes.
Yes, that is why I said, if you're concerned, you should seek legal advice on the validity, because sometimes when the testator does things like that, it is not always valid. It could not be held down. Like, for instance, some individuals put a clause in the will that you cannot inherit property until you're 30 or 40 years old. The individual may only be 10. That, in certain cases, is not valid.
Right.
There's certain rules that deals with the length of time.
Okay. Cool. All right. Makes sense. Let me see. Hold on a second. Hold on. I'll be with you in a moment. Is that a second? Okay. Can a claim be made for a lost or reduced inheritance?
Same thing what we've really been saying, isn't it?
Yeah.
If you think you should get more than you should, again, that's it, really petty, because it's another person's choice whether they leave you. But you'd be surprised, a lot of individuals, they like to contest that. Also, I spoke of this several weeks ago.
Mm-hmm.
You may have inherited a particular asset, but the debts of the estate needs to be paid first. So of course, if you lose your inheritance, what has been bequeathed to you, that's been lost. Some individuals, they contest that they are not too happy when they lose their inheritance.
Right.
There's other ways of losing their inheritance when they've received negligent advice from their attorney or the maker of the will.
Okay.
They could take action. This is known as a professional negligence claim.
Right.
Here, you will need evidence which is essential to succeed in proving your case. I'd like to mention some of these as well. Well, you need witness statements. For example, for those who may have been present when the person who died and was advising or preparing the will, or even when it was signed or witnessed. You can obtain witness statements from those individuals. Again, there could be independent records showing your inheritance. These could be such as the file of the company that prepared the will, especially if there are notes about what the person intended, or even their mental health at the time of signing. And of course, which is crucial in these sort of cases, expert evidence. This perhaps could be the mental health of the person at the time of signing the will.
Well, yeah. Yeah. Okay. Okay. Individuals. What happens to individuals who make false claims about wills or make false claims about beneficiaries out of jealousy, envy, sort of thing? Happens within families.
Yes, that still come under the consequences of declaring a will invalid. When that is petty arguments, and
Mm-hmm.
there's serious legal consequences of this.
Really?
We discussed that already, didn't we?
Yeah, 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 yeah. You did. What's the most common things that you face when dealing with a will, in your experience?
The most common is the three conditions to make a valid will. I spoke about that. There's the most common one is the testator, the person's signature.
Mm.
Many times a signature has been forged.
Ooh, naughty, naughty. How can you tell?
Well, the signature on the will may be different from the individual signature on company papers, maybe even
Wow.
on their IDs, because you know IDs now on your driving license, you
Yes.
have your signature everywhere. So
Yes, it's true.
it's very easy to check that. So that is usually the most important. And of course, also the witnesses. The majority of time, as well as signing the the will, to show that you have witnessed the signature. It is quite standard practice to put the witness's full name and address.
Okay.
That is because if the will is contested, you can contact the witnesses.
Okay. All right. Is there anything else you'd like to add, Miss Willis, this evening?
The three requirements, those requirements are statutory requirements under the Wills Act and also under common law. When I mention common law, it's law common to everyone.
Right.
And that usually takes the form of case law, cases between individuals, which are precedents for the court. So the three reasons or what makes a will valid is important. So I'll recap. When you make your will, it must be in writing. Certain wills can be done orally, but under the Wills Act, it must be in writing.
Okay.
The person making the will must sign and date the will. Those two are very important. You can sometimes get away with a date, but you cannot get away with the signing. But in most cases, you must sign and date the will.
Right.
And again, the witnesses, these are very important. The witness must be able to witness the testator's signature. So, as you say, blind person cannot
Can't see.
do that.
Can't see.
Okay?
Okay.
And you must appoint an executor to carry out your wishes.
Wishes.
So
Right.
it's somebody you can trust.
Mhm.
It's quite normal to put two executors. If one fails or refuses to act, you can use the second one. And remember, the person, your executor who deals with your estate, it can be professional where they're paid a fee, or it could be, I regard them as personal. You appoint somebody and they're not paid to do that.
Right.
Please remember, when you appoint them, sorting out your affairs can be difficult and time consuming. So
Right.
you should select an individual who's able to fulfill your wishes.
I do have a final question to ask you. If the executor passes away, then what happens?
A court can appoint a new executor.
Oh, wow.
If the executor is not, or another one is not selected in the will, the court can do so. So all is not lost.
Okay. 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 All right. I think that's about it for tonight, I think.
Yeah, it's a
Unless
very
you've got
short
anything else.
topic today, but it's a very, very important topic.
Absolutely.
And it's completely different from when you don't leave a will. As we've wrapped up quite quickly, we
Yes.
might as well just look on that. That is under the rule of intestate. Interstate means you have not left a will. You do not have you do not have executors, you have administrators.
Oh, wow.
And I must say, the common phrase, whether you leave a will or you don't, we usually say probate. But what is obtained from the probate court? When you leave a will, you obtain a grant of probate.
Okay.
When you do not have a will, you have letters of administration.
Okay.
And there's statutory rules of whom can inherit when there's no will. Of course, the first, if you're married, is your spouse. Then your children. The rules have full blood and half blood. Then you have your parents, grandparents, aunts and uncles. Please note, cousins, grandchildren are not under the rules.
Wow, grandchildren not under the rules. Okay.
Because they're far removed, isn't it?
Okay. Okay.
How's that?
Very good. Very good. Very good.
Yeah.
So yeah, we'll come back to it next week, and we'll with another topic on the same probate. I guess there's much more to explore, right?
Yes, it is. But it's when you understand the rules of making your will, it is much, much easier to understand and to follow through. And it's easier for your family and your friends if you do that. Someone is always there to carry out your wishes for you. And it helps the family and friends to move on when you leave a will, setting out what you need or want to do with your assets.
Yes. Maybe next time we can talk about the power of attorney. That'd be quite interesting.
Yes, power of attorney, that's a different thing altogether. And the power of attorney only lasts until the person is still alive. As soon as they die, the power of attorney has no effect. So that would be or will be a good one to look at. Like this subject, it's quite short, but quite easy to understand.
Fantastic. Miss Willis, thank you so much always for your legal advice. We appreciate it.
Thank you
as
very
always.
much.
And if anybody wants to contact Miss Willis, the email address is at the bottom. If you look at the bottom there, Herricia at HLWillis.com.
That's it. My surname, very easy to remember. HerriciaLWillis.com. HL Willis.
Okay. Herricia, as always, thank you so much, and we'll see you next week.
My pleasure. Thank you very much for having me.
Take care.
Thank you. Hello, good morning, good afternoon, or perhaps it's evening. My name is Herricia Willis. I'm an attorney at law practicing in Grenada for the past 6 years. As a slight background, I'm also an attorney at law in Jamaica and admitted as a solicitor of the Supreme Court of England and Wales in 2000. Well, I'm here today to inform you of wonderful news. I intend to advise and promote law in Grenada because